And a very pleasant Monday to everybody. Another one-on-one is off the ground. We're going to hit some smooth air here in a moment where things are a little bit turbulent in poaching land. And who better to talk to about that than attorney James Brody? He's a big name in the mortgage space. He's been in the business 22 years, is the founder of James Brody Gap LLP. I'm assuming that there's another person involved as far as the Gap is concerned.
But
Tell us about the Gap.
Yeah, so the Gap is Ron Gap. I had met him a number of years ago when I was representing the company he was at the time. And when I ultimately left to open up the practice, I wanted to make sure, number one, I had great lawyers, operational lawyers, ones that knew the business from the inside. Because there's so many great generalists out there. If we were going to really do mortgage banking the right way, I wanted to make sure I had people that could separate the gray areas from the black and the white, and obviously someone that I could really trust and lean on. And so Ron Gap was the one.
What's up, Ron Gap? Good to see you, buddy. Everybody knows you now. All right, let's get into poaching. Let's go directly straight head on into this because we've seen so many, more than ever, lawsuits in the mortgage space between mortgage companies for poaching. Poaching is the art of taking people from one lender to another. In terms of traffic, how much activity have you seen around legal pursuits in this realm relative to other periods of time?
Look, I mean, relative to other periods of time, generally what we see is when times are very good, a lot of people are investing their money into compliance, making sure they have everything built out. When times are a little bit rougher, when there's less money, they are more willing to fight about it. And so when things are tough and they see some of their LOs, maybe top producers or a branch, get swallowed up by a competitor, that's when, now there's two frames of thought. There's, I need to set an example so it doesn't happen any further. And then, they're really hurt financially, and they're trying to recover the damages to compensate.
Yeah. So how often is it posturing, just trying to stop the bleeding, compared to how often is it so material that there's real legitimate money at stake?
Look, I mean, we handle the one-off LOs, which usually don't end up in litigation. It's usually more when there's a branch, when there's a substantial amount of money at issue, because as most people who are involved in poaching lawsuits will tell you, sometimes the juice isn't worth the squeeze. So you have to really be looking at a serious amount of money or a serious principle, because otherwise the only winners are going to be the lawyers.
Yeah, well, believe me, I appreciate you saying that, because most attorneys won't say that. They'll just say, "Hey, here's my rate, and you need me."
Right.
What is that threshold where it becomes like really worth poaching? Or I'm sorry, what is the threshold by which the number is such that it qualifies as poaching, something that would get a judge's attention? Is it a group of 4, a group of 8, a group of 10? What's the most common ground framework that people should know about?
Well, legally, it could be 1. Insofar as dollar amount, I very rarely would recommend taking a case where there's less than $100,000 at issue, as just a base number, because the amount of money that it's going to cost you to litigate those types of cases is going to be, much more likely to be in excess of 100,000, and so then you're getting into a decreasing return. But insofar as number of LOs, it could be 1. It could be a top producer. They could have taken some CRM, and it's okay to move around. But what it's not okay to do is to steal the information that belongs to your employer in order to try to benefit yourself in the new company you're going to.
Yeah, I'm curious about hearsay, because there are a lot of situations where a loan officer, a big producer, might say, well, my manager told me if I ever leave here, I can take everything with me, right? And then, of course, you're going to want to know if that's in writing somewhere. And if it's not, and it was just a promise made, can that kind of claim hold up, or can you put that person on the other end of that argument, can you put them on the stand, and them, swear to tell the truth and nothing but the truth?
Well, you can bring those people in as evidentiary witnesses. You can subpoena them, get the documents, make them testify. But insofar as a promise, that's not secured by some sort of bargain for exchange, the judge is going to want to look at the four corners of the contract. Now, but where the hearsay comes in is not usually to prove the truth of the matter you are saying it, but to maybe impeach their credibility. If there is an admission of some kind, then that's not even considered hearsay. But the bottom line is that you would want to go ahead and make them testify, get all of the information, because you need to understand the exact circumstances, because there could be another legal issue, a waiver issue or something along those lines.
So we've lost people, we've gained people, and the way that we operate more often than not is we want to go CEO to CEO or legal to figure out what's an amenable solution, right? Yeah. And so that's our approach. There are some other people that are scorched earth. It doesn't matter who you are, what you say, they just want to go to war. What is typically the differentiator between the two approaches that you find out there?
Well, look, I mean, insofar as the scorched earth, again, that's usually being done to provide a principle. That the belief is that you go scorched earth, it's less likely that people are going to do the same harm to you, because they know that regardless of the amount of money at issue, they will go scorched earth. Now, usually those are the players with a lot, fatter bank accounts that can sit there and use that for principle. But for the most cases, going CEO business to business, trying to work out an amenable solution. It's like any other matter. I mean, like a divorce. It's usually until the partners beat each other up enough, understanding that the kid's college tuition is going to the lawyers as opposed to them, and then they find a way to resolve it. But we try to get that done in advance. So the more money we save from the lawyers, the more money there is to resolve those cases. But that doesn't always work, because you have scale. I would say most mid-size IMBs probably are open to that type of minimal solution. But sometimes the facts are pretty damning or harming. They don't want to go ahead and let them off the hook because they did something that was beyond the pale.
Mm-hmm. Yeah, and what are some of those things? What are the non-negotiables? Like, what is the handful of things where if you cross over this line, you're going to get it?
Well, I mean, look, if you go ahead and you are recruiting the other LOs to come on board, maybe you're still at the shop while you're recruiting for the future job, that you are taking documentation that leads to a data breach. You have to now notify the state AGs based on how many people, those types of things can aggravate the situation. And, when they do, usually the point isn't to inflict pain, but I have to say that there is a little bit of wanting to inflict pain, because only in the sense that they did something very bad. They hurt them. There's emotions involved. It's not just money when these things happen. But to the extent you can keep it to the business, trying to resolve it in an amenable solution, that's always the best way to go.
What do you think of consolidation? I don't think that's very good for what you do for a living. What if we look up one day and there are only 5 companies controlling 80% of mortgage?
Well, when that day happens, maybe I'll go fully into the AI space.
Yeah, and you are in the process of writing a book. I know it's pretty much to the end, and we're going to get into that around AI governance, because this is a really interesting topic that we're going to get into. But I want to still stay on poaching and that whole thing. How big of a business is it? The business of poaching. How enormous is it? How big are some of the cases that you've worked on? Would we know the names?
Yeah, you would. I have a number of them that are active public record, but nevertheless, it's as far as talking about those specifics, it's always attorneys.
But in terms of the ones, when you say public record, that's something anyone can discover. So
absolutely.
Throw out some names then.
Well, I'll go ahead and defer, but people can look my name up online. But what I will tell you is that insofar as your original question about these cases, um, loan officers are the lifeblood of the mortgage banking industry, or at least they are right now, and have been. And when you have loan officers and mobility, very rarely do I see loan officers be loyal to one company for their whole career. It's usually the grass may be greener on the other side, and market conditions, one lender may be more willing to try and up the ante with their LO comp, find a way to get them brought on because they know that production, when we do M&A matters, we're not selling desks, we're not doing desks, chairs, and office equipment. We're talking about production primarily. And so LOs are the lifeblood, and with them moving around, there's always going to go ahead and be that poaching, concern and issues. So I don't see it going anywhere anytime soon.
Yeah, I want to talk to you about this idea that a lender can give somebody a big signing bonus for 24 months, where if you stay through 24 months, it's all forgiven. But if you leave in the 23rd month and 28 days, that lender potentially, I'm going to ask you this question, has the legal right to go after all of that money, despite the fact that 718 of the 720 days or whatever the number is, has gone by. I mean, is that really the case? Is there a leg to stand on if you're a loan officer that rolls out 23 months into a 24-month contract because they've gotten a return? They've made a lot of their money. Do you feel like, can loan officers stand there? Like, what judge is going to look at that?
Yeah.
And how will a judge look at that?
Well, look, I mean, what judge looks at it depends on which state you're in, because we're talking about a lot of states, a lot of different state laws. In California, employment labor, I mean, it's a little bit more difficult, or regulated than some other states. And so you have an issue always of looking at whether or not that compensation was earned. So separate and apart from any LO comp rules, you have to look at the labor and employment laws of that state. So it may be the case that you go ahead, you do that work. That's considered money that you may have earned. Otherwise, it may be looked at like a liquidated damages provisions. And generally, when you're looking at liquidated damages, courts won't enforce it if it looks like a penalty. And so, if you're going ahead and trying to, and they're doing the work, they earn that money, and they're there for 98% of the amount of time, I think it would be very difficult for a judge to go ahead and say, hey, you know what? This is meant as an end run around the restriction on mobility. And as a result, I'm going to go ahead and say, no, you're not going to get that. But again, every case turns on its own facts. Each state.
All right. Well, let me give you another scenario.
Yeah.
You hire me, you pay me $200,000. It's not prorated, which I think all signing bonuses should be. I mean, if we can pass a law, it should be that law, right? Like, you serve your time, you pay your percentage, you're good. But that's not the case. That's not the case now. But you give me 200 grand for 2 years. It's not prorated. I'm there for 12 months. I decide to leave. To me, it's fair to say, all right, you gave me 200. I stayed half the time. Here's 100,000 back.
Yeah.
But that's not the way it is. It is now. Like, is that a defense that you can put forward if you're a loan officer? I mean, I'm trying to put myself in the seat of a loan officer, because this is a real struggle that a lot of loan officers have. Right. There are some managers at some places that will actually say to the loan officer, I don't care how much you bitch, you're stuck here for 2 years. I mean, to me, that's like mental anguish that they're having. No. And that, by the way, that really happens.
But you know what? And it's in that case, I really do think the LO, should be seeking counsel. When they're looking at that type of situation, because look, whether it's FTC or the states, there has been and it's been there for quite a while, a repulsion or revulsion against, forcing people to stay at a job and not giving them that mobility. And so when you are putting in barriers for people to leave and have that mobility, that is getting to the point where it's an end run around. It may not be something on its face, but it may be adding up to that restriction on mobility. And courts will generally not enforce it. Now, you have some states that are less revolted by that, and states that are more. California being one of the ones that would be more so.
Is a promissory note a better route for a company to go? Does that make it more sticky if it's completely outside of a contract? It's just a loan from an entity to a human being?
Yeah, there are ways to structure those. And look, I mean, on its face, if you're going ahead and you're very clear with the terms up front and making sure it is done in that type of way where it's maybe not earned, you might get around the labor and employment law of that part. But the bottom line is that you would need to look at these facts on itself and really make sure that you're not looked at, because people aren't going to want to go work for someone that is looked at as the kind that will entrap loan officers, force them to work, and that doesn't really do much good when you do that, because it will cause a lot of other problems outside of the law. I mean, just natural productivity, morale. There are other reasons too why you wouldn't want to do that.
Yeah. How about the companies that have built themselves by pillaging other companies, but that when they lose one branch, they go crazy.
Yeah. I mean, look, everyone has their own different business method, but what it comes down to is how did they leave? Or how did they do the actions that they did? Did they do it within the law? Is it really, and there are people that will go ahead and sue because they know that sometimes, how much justice you get is how much money you have. That's, justice and money sometimes have a correlation in the judicial system, a lot of times. And so, they may go ahead and just try to, put you into the ground by outspending you. And that happens in a lot of cases, especially with some of the bigger players, because they know that you're not going to be able to raise that type of capital to throw it at lawyers just to sustain it. So they are trying to crush you simply because they know you can't afford it.
Yeah. So James, in closing, and then we'll switch to AI, because we've got some fascinating stuff to talk about. What should a loan officer listening to this that feels stuck in a non-compete, what should they know? Like, where are the areas where they can look to for some wiggle room, whether it has to do with the state, language, whatever? Give a couple of tips to the LO that feels trapped.
Yeah, I mean, look, if there is an LO who feels trapped, really, they should be seeking a lawyer, at least to look over their contract to see what their rights are. I mean, because there's a lot of times people won't go ahead and do that because they think they know what they think they're stuck. But the reality is that the attorney may look at that document and say, look, you don't need to feel stuck. You are free to go. Now, as far as tips in this, at the end of the day, how you leave matters. So, if you do want to leave and you do have those concerns, now there may be some liability. I can't advise you without any facts. But at the end of the day, taking documents, taking CRMs, taking things that you should not, even if it may be, quote unquote, a normal or business as usual of how people leave. The bottom line is to leave clean. You have the ability to go ahead and get more business. That's why you are the producer you are. So don't go ahead and end up kidding yourself for a lot of money just to try to make a few shekels of putting taking a couple of files with you.
Yeah. What we found here is data. It's really all about it's about data and about approach. No one likes to have the rug pulled out from under them. So if you've got, and sometimes you take the right approach, you don't take any data, and still lenders take it personally and they'll go after you just to go after you. But that is the exception, not the rule. I have found in all these years that if you handle yourself with integrity and professionally, now where it gets tricky is when you've got processors and loan officer assistants and underwriters and loan officers, and that's when all bets are off.
That's right.
Yeah. All right, let's get into AI, because you have a book coming out here in the next few days that every lender is going to want to get a hold of. Mortgage Banker's AI Governance Guide. Tell us about this book and why every lender should be lining up to get it.
Yeah, well, so it's actually going to be released in mid-July, but I will tell you what happened was, number one, I'm a professed non-technologist. I was just a user of the LLMs, like a lot of people start out at a couple of years ago, seeing how amazing this technology was and advancing. We do a lot of regulatory compliance work at our firm, and so when I'm looking at the issues surrounding the use of AI, and I'm seeing, at least in the mortgage banking industry, a vacuum. That there was not much, and somewhat surprised, because at the end of the day, very rarely in your life do you find an area of law or an area of technology that simply is not being the ground hasn't been trodden well over and over and over again. So without seeing that, we realized that there was a need, and that's what we did. We started putting together a book based on an attorney's perspective of how you go ahead and incorporate the AI into the framework of your business, but do it in a legal way so that you can harness that technology without having to be worried about the liabilities. And you're always going to be worried about the liabilities, but the idea is that this is a desk book reference that maps to those liabilities, the different AI.
But James, do you have enough data though to know what's right and wrong?
Yeah, well, yes.
Data from the states, data from the governments, data from the agencies. Yeah. I mean, aren't we gathering that, compiling that by the minute?
We are, but we do have the current statutory framework. So fair lending, ECOA, GLBA. These may not say flashing lights AI, but they apply to all the AI tools. So if you go ahead and you put together an AI tool that is responsible for making some sort of adverse action in deciding whether or not a loan should be closed, well, you need to be able to trace that, audit it. You need to know how that decision came up. And a lot of times with like the LLMs and the other AI features, you're not going to be able to. And so being able to find out and trace how that's done to see whether or not it is going ahead and making decisions based on protected classes. So that AI feature is, again, squarely within the current statutes. And I think that's what people really need to understand is at this moment, they should be looking at all of the compliance laws as applying to AI. And everything that they would normally do needs to be applied in that way. There's going to be other laws. There is a vacuum of state law, but it's moving in a patchwork type fashion because the executive order from the Trump administration was a who, would, should, could. It did not give any sort of definitive parameters that people could count on. And this is especially true with the depositories. I'm working with the ABA right now to look at some of these issues, and the depositories in some ways are even further behind on these. So I think there's a vacuum.
Let me ask you a crucial question here. What do you view as the biggest mistake and oversight that lenders are making today that they need to think twice about when it comes to AI deployment?
I think education. I think being able to making decisions without proper education on the subjects is probably the biggest mistake. I think that there needs to be a concerted efforts for the C-suite to really understand. And that's what we are trying to do with the book. We break it down by C-suite role as well as the type of institution so that they each have a roadmap based on their position of how they should be looking at AI tools, whether the head of underwriting, secondary, marketing, HR, CEO.
Well, what does it mean? Well, education can mean a lot of things, though. Is education how to use AI, how not to use AI? The question was more so directed towards what is a way that companies are using AI that they need to think twice about. In other words, you're seeing that they're overzealous or leaning in a little too hard in a certain direction. My question to you, for everybody out there, is what is that one thing?
Well, I can tell you the one thing that they're making a big mistake of is they don't know what AI they are using right now. They're looking for the next AI tool, but they have already ingested all of this AI. So what they really need to be doing is inventorying all the AI that they currently have. Are the LOs using $20 chatbots? Was there an AI feature that came in through an update on the LOS? Does their contracts contain provisions in there that allow them to manage their vendors and comply with the new mandates of Fannie and Freddie. So the point is, they need to make sure that they know all of the different AI that they have. Once they do that, then they can start to, lift it up, look at the contracts where they come in, put in policies for their LOs. And, look, people are going to use the technology regardless of whether it's allowed or not. So the best thing to do is to find a way to harness it in a company on an enterprise basis to give them that tool that they can manage so that they won't need to outsource or use shadow AI. And
James, this is a big ask.
Yeah.
This is a really big ask that you're describing.
Absolutely.
It is so big
Yeah.
that it's almost too daunting to even think about it. Like, we have hundreds of third-party vendors. What you're saying is understand what they're doing on the AI front and how they're bringing certain data to us and other things. So my question to you is, just putting that noise to the sideline for a moment, who's liable in the instance where a vendor brings something into your ecosystem that turns out is not defensible? Is it the vendor or is it the lender?
Well, the lender is clearly liable, for the acts of its vendor that it is using, to the extent, they need to make sure, because look, Freddie Mac has a standalone indemnification, if there are losses associated with AI being used by that lender. I think Fannie is silent on it at this moment, but they're moving in the same direction. So, but even though the lenders are the one responsible, and as for daunting, absolutely. We are moving into a new world here. It's not meant to be easy, and people have to understand what the issues are so that they can address them.
Isn't it possible that I'm thinking out loud, like, what if you just came up with your own, as a lender, your own uniform policy for when AI is interjected, and you give that to your vendor, have them fill it out and say, no, we're not doing that. And then if they refuse, then potentially would you have maybe a breach of contract and be able to get out of these? Because that's the thing, and I know that the secret sauce for vendors is to tie people up in seat minimums and long-term contracts. Could AI be the out that lenders have been looking for?
Listen, it very well could be, depending upon that contract term. And so, when I say go ahead and inventory all the AI, I'm also telling them to pull every vendor contract. Now, at the end of the day, the vendors, may think that they don't have to comply with these, some of these laws. Hey, what does fair lending do to us? But the bottom line is, they are trying to sell a product. If they want a product to be bought and used by the mortgage industry, they're going to have to understand that putting the onus on the lender to come up with that package to provide Fannie, Freddie, or whomever else is going to be a disincentive for them to use that product. So that's why we, absolutely believe the vendors right now, before they're forced to, they can come out looking like the heroes by doing this stuff themselves and coming to the market and saying, look, our product is going to, we have the evidence package you need when you go ahead and purchase our product, because we are looking at making sure it's going to be compliant with fair lending. You don't have to worry about that. We have taken that step, and here it is. That's something you can stick in your file, and you can give it to the regulators when they ask for your package.
To my question, though, would you advise lenders to grab somebody like you, come up with some kind of a boilerplate to deliver to their third-party vendors? And if the third-party vendor says, no, we're not using any of this technology, they sign on the dotted line, you continue to go down the road, and then 6 months from that date that they sign that, all of a sudden you discover that they lied, or they have, because one of the things on that paper could be, if you choose to introduce, you need to run it by us first, right? What if they go right past that gatekeeper and they interject something into your workflow that turns out to be problematic? Is the lender okay there? Two questions. Do you recommend a lender consider doing that? Is that one pager thing a real idea that I've come up with? And secondly, if they do that, if they cover that base, assuming you say it's a smart idea, are they covered?
Yeah. So I look, everything depends upon what the contract actually says and the state it's in, and what actually the vendor says in response. But there is, to your point, I think the better way to shape that is a couple things. There's one, going ahead and setting up an industry norm about what the expectation is for these vendors when it comes to the AI, what they should be able to provide to the lending community. That may be one issue. That's maybe more advocacy, though. Siloed, if I'm talking to, a lender, depends on their size. Maybe they are a small shop. Maybe they're a big one. Maybe because when we negotiate contracts with vendors, with investors, you can't take out the fact that, some of them are small, some of them are big, and they're going to make modifications to contracts based on your size, how important you are to that relationship. If they stand to make a lot of money on you, they're more likely to make contractual changes on a renegotiation. If you are just barely able to meet your net worth, whatever, they're not going to make as many changes. So the point is that you absolutely should be looking at all your contracts insofar as what you do to them to try to give yourself an escape clause.
What are you looking for? Because a lot of these contracts are 2, 3, 4, 5 years, depending on who's on the other side of this from a vendor perspective. AI then wasn't what it is today. So I mean, who the hell has that covered?
Yeah, so if they are using AI, and they should be disclosing, and there's going to be state laws, I think, like the Colorado, the debate, is going to put more of an onus directly on the vendors. In California, there may be some opt out or opt in. There's a lot of different things happening with the law. However, if they are utilizing AI, and that AI comes in contact with any private consumer financial information, if it stands, if they are incorporating something like a new calling technique that's reaching out, consumer facing, you have TCPA potential violations. They can still sue the vendors if they go ahead and cause them. Number one.
So this is such good stuff. So I don't want it to be completely one-sided. Right now, I'm coming at this from the lender perspective. I want to ask you if you were advising vendors right now.
Absolutely.
Because I've not heard anyone talk about this. So I want you to address the vendors out there and tell them what should be keeping them up at night and what they can do about it.
Look, all of the vendors out there right now, if they are dealing with sophisticated lenders and investors, and there are sophisticated ones out there on the AI issue, they know that they're being asked the questions about whether their AI involvement will have any potential impact on the current statutory framework and cause any problems. They're being asked to provide information. And so rather than going ahead and trying to duck and weave around that, they should be planning on putting out a package, because it's, number one, setting aside the law, it's good business. If you want to do business, you're going to want to make sure that the customers know that, hey, if it comes down to me and a similar product, and I have done the homework to make sure that we are really looking at this product and whether or not it's a safe product for you and the consumers, you're going to want to spend the money on that product where they have the foresight to do this. And if anything bad happens, the worst thing possible is that you get egg on your face and you're back to R&D to try to get these things tuned up. And by that time, you're left in the dust in competition. So
well, you say that, but a lot of these vendors are already hanging on by their chinny chin chin. They thought that the market would get better 2-3 years ago. So they're living, I don't know, like dangerously on the edge. So going back to R&D, easier said than done. What is like, we keep talking about this thing. I don't really feel like we've peeled it back and drilled down on exactly what the danger is here. What are a couple of be very direct with me. What are a couple of the things that vendors should be looking out for that they should absolutely not be doing with AI right now? You mentioned the TCP. So I understand, calling people with agentic AI without them knowing. Good. We took care of that. What are some other things?
Fair lending, huge. If you are going ahead and interjecting a product into the underwriting process and you are using AI, and look, even the people who created AI don't fully know how AI, works. And so you have issues like drift, hallucination. Anyone that uses an LLM understands that it's not always just garbage in, garbage out as far as prompting, but you can ask the same question a number of times and get different answers every single time. And so you need to be able to put the guardrails on in place. And there are ways to put those guardrails in place to make sure that you are not ingesting data of protected classes, and you have a system that allows you to go ahead and make sure that that hallucination, that drift, is not going to interfere and cause a problem with the fair lending. And I can tell you what we have done in order to try and help the vendors with that, because we think that the vendors right now have a special obligation because they're coming out with these, great tools. The efficiency is amazing, but at the end of the day, they need to have the safeguards. And so that's what we did, was put together an AI audit. We brought in a fellow named Marvin Chang from Duke University to help us put the technological overlay on the audit, trace the information. And really what we're saying is, look, as lawyers, we can provide a limited attestation, as we did for Friday Harbor AI. Obviously can't get into each one. Is a scoped legal review and looking at their system and trying to say, okay, well, there are problems here, here, and here. You need to go try and remediate and make sure that you have those safeguards in place. And by that process, you have something that you can tell customers, I have been going back. I have been trying to make sure that our product, because you can't make guarantees in this. When it comes to AI, very rarely can you give a guarantee, but you can surely show the homework being done, the effort, and some level of reps and warrants.
Yeah, and that helps, right? Just to show that you were trying to do the right thing. As I'm hearing you talk, I'm thinking about when we got all those margin calls around rates, dropping precipitously around COVID, and all the covenants that were broken and all the exceptions that were made. Every single lender who had covenants to show that they were profitable, they didn't have 2 unprofitable quarters or whatever the bogey was, right? Every investor, every bank looked the other way because everybody was in the same boat.
Right.
I'm wondering if this is a similar moment here where everyone's in the same boat, right? We don't have the rule book. We don't have the guidelines. So I'm wondering if there'll be some leniency when we do start to figure this thing out.
But absolutely. In writing this book and going ahead, and trying to make sure that there was a common set of guides, in addition to Mismo, which is doing an amazing job, of going ahead and trying to bring in the vernacular and all the other things that they're doing to have some consistency. And, we're trying to do the same thing a little bit from more of a legal perspective, so that, they can look at those issues of liabilities. But as far as going ahead and the having a little bit of a laxer attitude, we've been talking to Fannie and Freddie. Freddie has said that in their guide, this is just the beginning. They have full intentions of going much deeper. But this is to break in the industry and let them be able to understand these issues. And there has been discussion that on a case of first instance, if there is a problem outside of looking at the scienter intent, that they're not going to go ahead and give such a lashing for some mistakes that may be unintentional, that may be because of that confusion. But they are moving forward. Freddie is already active. Fannie comes active August 6th. That is just the beginning. And so this is an evolution of the education of all of these things. And that's what we're trying to help with.
James, you made a really interesting comment to me as we were prepping for this one-on-one.
Yeah.
And that was about advocacy capital.
Yeah.
Tell us what you mean by advocacy capital as it relates to AI, and why you feel like that capital will be diminishing day by day.
Well, look, at the end of the day, when it comes to this issue and any important issue that affects our industry and the nation, you're going to want to make sure that you have advocacy out there. Right now, the advocacy is, effectively, let's get some clarity on the laws. We don't need more laws. We have the current existing statutory framework that helps. But at the end of the day, when it comes to the amount of capital you have, and I just wrote an article, I haven't released it, on who speaks for the loan officer. When it comes to the advocacy part, you have, in this current day and age and past, workers could leave. They could affect change much more readily by using labor and those tools. But now, as AI continues to increase and it's moving forward at a compounding rate, the amount of capital you have to effectuate change and advocacy is going to be diminished because it's moving slowly, and there's a debate on how far it will go and how far it won't go. But the bottom line is that people are losing more and more power because they will be relied upon less in some of the more senior jobs.
Do you think that you think the Mortgage Bankers Association sees the urgency that you see? Can you go on the record with a real, true, honest comment on that?
Yeah. So what I can say, and I put this in an article, and I will stand on it, is I do agree with their position right now. But I think that what we need to do is make it very clear that when it comes to like the loan officer versus agentic AI, I mean, we already have the SAFE Act, which you can rely on and saying, look, for agentic AI that wants to ultimately get into some of these licensable activities, the way the statute is set up, is that it requires a human. You need to be fingerprinted. You need to sit for the NMLS. So there is a law already in place that can be looked at insofar as kind of driving a wedge into that debate of the LO versus the machine, and that may be somewhere out there. But the way this this technology is developing, again, I don't think anyone has a crystal clear idea of how fast it will go.
Should the mortgage industry be advocating for agentic loan officers?
Well, I think with regard to agentic loan officers, I think there's always going to be a push and a need to try and improve the technology that will allow efficiencies. But I don't believe that there should be an effort to replace if that is there. But again, we have laws that would stop that, at least in looking at like the SAFE Act, because agentic AI, if you're trying to go ahead and allow it to do those licensable activities, now there's a counter argument. I don't think anyone would go on the record of making it insofar as that's that agentic AI, or maybe that AI agent is under someone else's license, and so they're responsible, and so therefore I don't think that would be a good thing. And I think it comes down to the fact that people want to have human interaction, no matter how convincing the AI sounds, no matter if it's Grok that has a whole other element to try and make it a little bit an interface.
James, how can people get your book? How can they line up?
They can go right on our website and set up for a reserve copy. They can look at some of the information. We put out a lot of articles on this issue, as well as go to my LinkedIn. They can find it.
What's the website? What's the domain?
So www.brodygap.com.
That's GAPP. Nobody says, hey, listen, nobody says www anymore.
Thank you. Yeah.
Great talking to you. This has been amazing. Well, we'll have to do this again. Obviously, this is developing at the speed of light in terms of AI.
I appreciate the opportunity.
Yeah, thank you so much. Enjoy your Monday, everybody. That's it for this edition of One on One. James, stick around for a moment, and we'll see you all later.